Welcome to another legal talk on eRadio with Hahn and Hahn attorneys. Last week we spoke to Hahn about the medical aid schemes and the clawback clause and the Medical Schemes Act. And carrying on with that discussion this week, we've got Reinier Rotenbach from Hahn and Hahn, who's going to tell us a little bit more. Reinier, welcome back to Legal Talk. It's been a while. Are you well?
Yes, it's been a while. It's been how many months now? Oh, the last time it was last year.
It was last year. It hasn't been this year. Yeah, no, it's been a while. But you're back, and we're carrying on with this discussion that we had last week. Rennie, let's start with the basics. Can you explain what clawbacks are and also why they've become such a contentious issue?
Yes. As referred to previously by Jaco in his podcast session last week, clawbacks are when medical aid schemes retrieve money already paid out to the practitioners. They often do this under Section 59 of the Medical Schemes Act. But the concern arises when it's done unfairly or without valid reasons. Now, just to point out quick, there was an interim report by the Council for Medical Schemes wherein an investigation was conducted in respect of the schemes enforcing their rights in terms of Section 59 of the Medical Schemes Act.
So how do unfair clawback processes violate principles like due process and presumption of innocence, Reinier?
Okay, unfair clawback processes lack transparency and accountability. Now, practitioners may face deductions without sufficient evidence or even a chance to defend themselves. And this in turn then violates their right to a fair process and presumption of innocence.
Are there any specific measures that medical practitioners can take to protect themselves against unfair clawbacks?
Yes, medical practitioners should ensure they have a clear and transparent billing practices, maintain detailed records, and be proactive in addressing any concerns raised by medical aid schemes. Additionally, they should familiarize themselves with relevant regulations and also seek legal advice if necessary.
Now, you made a mention of an interim report by the Council of Medical Schemes. Can you tell us a bit more about it?
Yes, and in brief, the interim report, as I mentioned, came about by the Council for Medical Schemes in launching an investigation into allegations of unfair treatment. Now, the Council for Medical Schemes found that some of the current procedures followed by the schemes to enforce their rights in terms of Section 59 of the Medical Schemes Act are indeed unfair, including unfair discrimination. Now, I don't want to get into the technicalities, but I do need to emphasize that medical practitioners should not blindly sign acknowledgement of debt agreements and bind themselves to the schemes without seeking legal advice. Yeah, and they are more than welcome to get in touch with us regarding that.
And that's Reinier Rotenbach from Hahn and Hahn Attorneys, keeping it short and sweet here on this week's Legal Talk. If you want to get in touch with Hahn and Hahn on this matter, you can call them on 012 055 2142. That's 012 055 2142, or check out hahnlaw.co.za. Reinier, thank you so much.
Thank you so much, and thank you to your listeners for listening.
Are you or your business in trouble and struggling to find a solution? Call Hahn and Hahn Attorneys as we assist clients in finding solutions. We specialize in consumer and food law, commercial and construction law, forensic investigations, and administrative law. Visit hahnlaw.co.za. That's HAHN. We assist clients nationwide. Hahn and Hahn Attorneys, because we care. Don't miss Legal Talk with Hahn and Hahn Attorneys, Wednesday mornings at 10 on eRadio.